question of a response. It benefited me in the sense that I did read it carefully. And then, of course, Mr. Dean, I think I got something from you, like at midnight, some affidavits. You must have trouble sleeping.
I do, Your Honor.
I assume those are for Friday's hearing.
Yes, essentially.
All right.
Yes. And excuse me just a minute. And Your Honor, I will apologize in advance. The night before Memorial Day, I got brutally sick, and there's something wrong. There's still something wrong with my throat. So whether my voice lasts, I don't know. I'm surprised it has taken this long, but it continues. So if my voice falters, that's why. And I ask the court's indulgence. I will have to from time to time cough or and I'll try to mute and to avoid that kind of disruption. But my apologies.
No need to apologize, Mr. Dean. I'm sorry for your condition. It's all too often becoming the new normal in dealing with these types of problems. I'll certainly feel free to accommodate. I will accommodate you in any way I can as we work through this hearing.
Okay, thank you.
Mr. Dean, so we really have two motions, I think, or at least a motion and a request. You move to strike on various grounds or quash the subpoena of Mike Gableman. We also did receive Ms. Westerberg's response that makes various arguments, and then I think reasonably construed to suggest that if I was inclined to accept your argument, then plaintiffs move for leave to amend the witness list to include Mike Gableman for good cause shown. Mr. Dean, I'll give you the opportunity to reply to the arguments made by Ms. Westerberg.
Okay, thank you, Judge. I'm sorry, here we go already. In relation to the matters that were filed last night, which are relevant to, or early this morning, all of those documents, those are under affidavit of Attorney Milburn, and essentially, or not essentially, they do now put of record with the court the two groups of documents that really are at issue. The first one, which is Exhibit A, and I'm giving this as background because it relates to what's actually at issue in this motion. Exhibit A is a group of contracts, calendars, and a few miscellaneous documents that were in fact in the possession of the Office of Special Counsel and were inadvertently omitted from the production on January 31st. There's no dispute. The only question on those was that omission intentional, and those were identified and produced under cover of letter of Attorney Milburn's letter, April 8th, and I just put those. I filed those with the court, so those responses would be of record, and to the extent that that filing was necessary now at this point to comply with the court's January 25th order, we have done so. The second group of documents are all of email attachments that were deleted probably, my recollection is sometime in November or December of last year, before the litigation was even instituted, and certainly before the court's order. And there will be testimony, of course, that Mr. Nemirovich, who was chief of staff and responsible for the hands-on conduct of the document requests, printed off hard copies of all responsive emails, and again, probably no dispute. One could argue technically that attachments are different than emails, but we're not going to try to make that kind of technical distinction. And so, even though, for the sake of argument, if we can see that the deletion of the attachments was inappropriate, that was done prior to the January 25th order, and there was no, and it'll be our position, of course, that there was no intentional violation of the court's order by failure to produce email attachments that at that point did not exist. Exhibit B that we filed last night to Attorney Milburn's affidavit is all of those email attachments, which were under cover of a letter dated May 13 and produced to counsel, and Mr. Nemirovich was able to contact all of the parties to those various emails, and through that process was able to recover all of the attachments to all of those emails, and those are all filed. The only exception, the only attachments not filed were a couple drafts of an interim report, and based on our understanding of the vagaries of Google Docs, which was the platform that various parties in the Office of Special Counsel were using to draft that particular document, that particular application or platform apparently deletes automatically interim forms or interim drafts of a particular document. So in that, unless when we're supposed to subpoena Google and try to recover something, those are simply, as far as we know, don't even exist anymore, because on that platform, when there's a subsequent version of a document created, it automatically deletes prior documents. So the bottom line is, other than those handful of interim drafts or preliminary drafts of the interim special counsel's interim report, literally every single document that was responsive to those requests has now been produced, and in the case of the email attachments, has been recovered and produced. So as we talk about what might be relevant or petitioners' response arguments, it's important to keep those two groups of documents in mind, and I refer to them generally. And I will also say the reason for I discovered something about the Wisconsin e-filing system yesterday. The size of the attachments that were permitted to file is relatively small, and so unfortunately, because of the volume of the email attachments, I had to break up that particular submission into literally 33 separate individual files, and so that was not my intention to burden the court or create that kind of volume of filings. That's just a function of the size limitation of the attachments that that the system allows me to upload. So for housekeeping purposes, that's the explanation why the multiple individual parts of those documents were filed. Then moving, excuse me. So with that said, moving on to to reply to the arguments raised by Attorney Westerberg, one of the first statements that petitioner makes is that the scheduling order applied only to the Office of Special Counsel. That's not correct, and I'll explain that in a minute. The second one is, there was a comment early on that Zach Nemirovich was the legal custodian with decision-making authority. And unfortunately, because of my illness, we were not able to conduct the deposition on June 1. And so we're both dealing with the difficulty of not yet having a full transcript. And so I will make representations about Mr. Nemirovich's testimony, as did counsel. And in that testimony, what's omitted from petitioner's discussion of the testimony is that Mr. Nemirovich repeatedly testified in answer to multiple of the same question, repeated in many different forms, in many different ways, that subsequent to this court's January 25th order, the Office of Special Counsel has not destroyed any documents responsive to the open records requests. And as I mentioned before, the ones that were inadvertently omitted, that goes to the destruction. There has been none. The ones that were inadvertently omitted from the January 31st production, as I already indicated, has now been submitted to the court under Exhibit A. It was previously produced to petitioner under letter dated April 8th. And those were the contracts, calendars, and a couple miscellaneous documents that Mr. Nemirovich testified were he had collected and kept in a separate subfile, and simply inadvertently failed to include those. I don't remember that he had that file and failed to produce those documents to his counsel, so that when we, as counsel, filed those documents with the court, or I did, those particular documents were not among them. He has since identified that other file, and again, those were produced to petitioner under cover of Attorney Milburn's April 8th letter. They have now been filed with the court. So the Office of Special Counsel, subsequent to January 5th, has destroyed no documents. They have subsequently produced every last document that was in existence and inadvertently admitted. They have also, other than those several versions or drafts of an interim report, have recovered and have produced to petitioner and are now in file with the court all of those email attachments that were deleted and were not in the possession of the Office of Special Counsel on January 25th. I would also add, Mr. Nemirovich testified and will testify Friday that literally every last document that is in the possession of the Office of Special Counsel, other than a small handful of highly confidential, personal information, has been posted to the public and is now available on the Office of Special Counsel's website. And then he also testified that in response to the open records request, he reviewed those documents, those requests with Attorney Gableman. Justice Gableman instructed him to produce all responsive documents, and that he did so. And he will testify, and did, at the deposition, that he was personally responsible for compiling and producing all the responsive documents that at the direction of Justice Gableman. And then on page 5 of the petitioner's argument, they mentioned that they referenced this general duty to testify and that there's no exceptions. Well, that's of course a grossly overbroad statement. If that were the case, any party at any time could simply ignore a scheduling order and create a duty to testify and a right to have a witness appear simply by issuing a subpoena. That general statement of a duty to testify obviously is subject to the ordinary operating procedures of the court, Section 80210, and the court's normal operating procedures. So the mere fact that there's this general duty to testify does not in any way defeat the requirement or vitiate the requirement of ordinary judicial process, that when a court sets a scheduling order controlling the appearance of witnesses that it is that scheduling order that must be honored. And that was the case, and this court's scheduling order was docket number 208. Petitioner argues and cites some language from the hearing at which that gave rise to that order, making the argument that order applied only to the Office of Special Counsel. That's simply not the case. The order itself says witness lists, plural. The Office of Special Counsel was not ordered to submit multiple lists. The order says point blank, witness lists shall be filed by May 10. The fact that is plural, it never occurred to me, I think, or to anyone, that when the court says witness lists, that was supposed to mean only witness list by the Office of Special Counsel and not by all parties. So we have proceeded in not merely good faith, but reasonable reliance on the court's direction that all parties were required to produce their witness lists by May 10. And there's no dispute that they have not done so, and even now they have not attempted to modify, except implicitly, as you point out, move to amend the scheduling order or seek permission to now name a witness belatedly. The argument that they raise, I think, which is probably the main one, is that Justice Gableman is going to be called in rebuttal, and that is because it says petitioner submits that they are calling him in rebuttal because Mr. Nemirovich's testimony confirmed suspicion that there were certain things afoot, but as I've said it before, there's no suspicion to confirm. Mr. Nemirovich has testified, and there's literally no dispute that every last document responsive to these requests was preserved or recovered and has now been produced both to counsel and to the
Let me ask you a question, Mr. Dean.
Yes,
Mr. Dean, as to that, this has not been discussed by the parties, but it weighs heavily on my mind. Mm-hmm. The original request from American Oversight asked that the documents be produced in digital form, which is allowed under Chapter 19. There's no doubt that, I guess there's no dispute that the Office of Special Counsel, I guess, unilaterally and summarily disregarded the request that they produce the digital copies, and that's not been done, right?
As far as I know, that's not been done. But again, this is the reason I began the way that I did, to distinguish what's at issue. There is no, even assuming that's the case, and at this point, as to my knowledge, those, and I believe that's the testimony, that the digital files, the emails, for example, were in fact deleted. But those were deleted prior to institution of the lawsuit. They were deleted prior to the entry of the court.
But were they deleted prior to American Oversight's public record request?
As far as I know, they may or may not have been, but I would concede that let's say for purposes of argument they were, and I think it's highly likely that some or all may have been deleted, at least some may have been deleted after receiving those requests. And I would let's say concede for the purposes of argument that was a direct violation of the open records law at that time. And again, but this again is why I began my responsive argument today the way I did. That's not an issue. The only matters at issue right now at this hearing on Friday and at this motion now is whether or not subsequent to January 25th, the Office of Special Counsel deliberately or intentionally ignored and violated the court's order. What's not at issue is whether there were violations of the open records request at some time prior to that, and because there is a final order in this case. This is closed. The case is closed. Had the petitioner chosen to pursue a cause of action for prior violation of the Open Records Act, they had every right to do so and to seek sanctions for those prior violations, but they did not. There was no amended pleadings to that effect. There's been no order, no finding on that effect. And because there's now a final order which has been appealed and jurisdiction for that final order is now with the Court of Appeals, it's way too late to say that those prior violations, which I concede for the sake of purposes of argument only, those are not relevant now to the issues that are now before the court, which is the subsequent violation of by the Office of Special Counsel subsequent to the January 25th order of the court. And I would also observe, and this is one of the most interesting jurisdictional and procedure issues I've run across in a long time. The fact is that the court's final order was entered on March 8th, and therefore the question to modify that order under 80607 raises the question: is that appropriately brought? I don't know. And I'm sorry, now I do not recall the actual date, but the point being that this court's order, it may have been later than that, but it was entered prior to this motion at a time when the petitioner was already aware of the deficiencies, but they failed to seek pre-judgment relief from the deficiency. Are they now precluded as a matter of law from seeking post-judgment remedies for under 80607 for deficiencies that they were on notice of prior to the entry of the court's order? I don't. Ultimately, that's probably going to be cited by the Second District Court of Appeals. I don't know, but it's an issue that we would raise. But again, in response to your question, which I think is certainly a reasonable one, I would suggest that even assuming that there were violations of the open records law and a deletion of the electronic files in violation of the law and in violation of the request, even conceding for the purposes of argument that those occurred, those are not relevant to the current issues before the court, which are limited solely to violation of the court's order post January 25, and there's no dispute that those electronic records were deleted prior to that, and had they existed and been deleted after that, then very different question. But they were not; they were deleted prior. Thank you.
All right. Ms. Westerberg?
I did have.
I'm sorry.
I'm sorry. Yes, I was. By thank you, I meant thank you for the opportunity to give an extended response to your good question. So I have a few more remarks going to.
Go ahead.
So the question is, the argument is made that Justice Gableman is appropriate a witness for rebuttal. The discussion I just made was that there's nothing at issue to rebut. There's no testimony. There's no evidence that he has any information on firsthand on the collection or production of documents, which were the sole responsibility of and conduct of Mr. Nemirovich.
Let me ask you this, Mr. Dean. Does the Office of Special Counsel concede that it did not comply with the court's January order at the time the documents were first produced?
Yes, I believe that's already conceded, but only in respect to, it's my understanding, and I'm at a bit of a disadvantage, Judge, and I apologize because as local counsel, virtually all of that housekeeping was taken care of by Mr. Bob's office and Attorney Milburn, and for because I was local and handled the deposition, I'm also handling this. But it's my understanding, my recollection that that has been conceded, but only in respect to what is now Exhibit A. Those, I don't believe there's any dispute that those documents were in the possession of Office of Special Counsel and were not produced. And the only question is, was that an intentional or an oversight?
But I want to draw your attention. I don't want to catch you in the middle, Mr. Dean. Mr. Bob, at our last hearing, when I said something to the effect that I didn't believe it was disputed, that the Office of Special Counsel failed to comply with the court's order, and when I discussed then proceeding to the shifting burden of proof on a motion for contempt to allow the Office of Special Counsel to prove it was not intentional, at the transcript, page 26, lines 20 and 21, and transcript 28, lines 1 and 5, Mr. Bob, I think strenuously objected to my essentially denying the Office of Special Counsel's ability to litigate that preliminary issue, and that, in fact, it was not conceded. If you want to bring that up to refresh your recollection as to what actually Mr. Bob said, my question is, which is it for Friday's hearing?
I'm sorry, yes, I do have that in front of me. And could you direct my attention? What pages was that again? Where that?
Transcript line, page 26, and examine lines 20 and 21. Now, this comes at a point in time where I had said that here's what we'll do at an evidentiary hearing. We'll hear from the Office of Special Counsel as to why it does not believe it intentionally violated the court order. And you'll see Mr. Bob said he was somewhat puzzled that I should make that finding without giving the office the opportunity to be heard on it, and refused to stipulate that there was a violation of the court order.
Oh, yes, and I do see his...
He goes on at page 28, lines 1 through 5, and double down on reserving the right to argue no violation. My question to you, Mr. Dean, refreshing your recollection of the statements made by co-counsel, is it now the Office of Special Counsel's position, and does it concede that it violated the court's order? Or does the Office of Special Counsel want to pursue the matter as suggested by Mr. Bob at the last hearing?
No, I do see at page 26, lines 20 and 21, he says, I am not prepared to agree to that at this time. And subsequent to that, in conversations with, obviously with discussions with the client, I don't believe that there's any dispute now that what was submitted last night, or again, this group of documents that we submitted under attorney as Exhibit A of Attorney Milburn's affidavit last night or early this morning, consisting of some calendars and contracts, and I think there were a couple other miscellaneous documents. There's no dispute that those were in the possession of the Office of Special Counsel on January 25th at the time of the order. They were not produced on January 31st, and again, that was my reason for explaining the testimony of Mr. Nemirovich this past Monday, that those documents, he had collected them, months before, weeks or months before. They were in a separate hard file, which he neglected to recall and did not produce to his counsel, and therefore they did not end up filed with the court. But he subsequently located those, and those were produced to the petitioner under letter of April 8th, and they are now filed with the court.
Okay. The court acknowledges your concession on this point, but it's only made today, Mr. Dean. Up until this point, I think a fair characterization of Attorney Bob's statement was that Office of Special Counsel heretofore had refused to concede the point. And so your statement in page 3 of your brief, document 255, is not exactly accurate until this point in time in which you now concede the point.
Excuse me just a second.
Page 3 of your brief, the second line from the top, you indicated that the Office of Special Counsel conceded this point. And I think we've drawn your attention to the appropriate transcript page and lines to say that Mr. Bob actually refused to concede the point.
Oh, now I understand your question. And again, because I was not the one drafting the letters and taking care of the housekeeping between Attorney Milburn and Attorney Westerberg, I did not zero in on that statement. I would say it is accurate to the extent that the Office of Special Counsel in those letters definitely conceded that point to petitioner. And I think too, I certainly appreciate the court's, there's no reason the court would continue to be, and actually that letter was attached, I believe, to one of Attorney Westerberg's motions, seeking to modify the injunction. But I would certainly understand that the court was not aware or did not zero in that in those letters that point was conceded to petitioner. Okay. And so at this point, certainly we do. Now I understand, and my apologies.
No problem, Mr. Dean. Mr. Dean, then my next question. In understanding your argument that everything has been produced, there's really nothing for Mr. Gableman to testify about, and so therefore I should relieve him of the obligation to appear on Friday. Does the Office of Special Counsel concede that it intentionally violated this court's order?
No, not remotely.
So if the Office of Special Counsel does not concede, even remotely, the argument that it intentionally violated the court's order, why then would I deny the American Oversight the ability to make inquiry of Mr. Gableman on that point?
For the scheduling order that we've talked about, and second, the question, the only testimony at this point in time, Mr. Nemirovich testified repeatedly that he was instructed by Justice Gableman to.
How are you going to get that into evidence?
Pardon?
How are you going to get that into evidence on Friday? Isn't that hearsay?
No. It would be hearsay if it were offered for the truth of the statement. What is not hearsay is the fact of Attorney Mr. Nemirovich's receipt of that instruction and saying, yes, in fact, I followed that instruction explicitly, and therefore, since he was the one that was the only one responsible for collecting and ultimately compiling and producing the documents requests, he's the only one who can testify whether or not he in fact did so.
Okay. Anything else you'd like to add before we turn to Ms. Westerberg, Mr. Dean?
Yes. I can check some of my notes. There are a couple other comments that the court may find relevant. The petitioner says the didn't know how Zach would testify. Well, that's again not to be dismissive, but if I were to, as a litigation counsel, compile witness lists on the basis of not knowing, of excluding potential witness from a witness list on the basis of not knowing what he might testify, I would be malpracticing. I would also note that if they had the suspicion that Mr. Nemirovich would testify in a certain way, they to date have not noticed Attorney Gableman's deposition at Justice Gableman's deposition at all, which certainly they could have done, and in the same way that they noticed Mr. Nemirovich's. And so apparently the intent is to or the hope is to bring Justice Gableman and have him appear as a witness and conduct discovery at trial. That's actually what's going on. If in fact the court does not seeks to compel Justice Gableman to appear, the good cause standard, which is argued at page 8 of petitioner's response, addresses whether or not Mr. Nemirovich is legal custodian. The statute obviously indicates that Justice Gableman is the legal custodian, but also authorizes him to appoint a person to carry on that function, which he did so, and this document that was recently filed, referred to by counsel, is simply a memorialization to put that in writing, which we also we understand is a requirement or provision in the statute that a designation of someone to act as in compliance, and I forget the statute site, but at any rate, there's the statute authorizes a legal custodian to designate someone to act on his behalf. That's the only reason for that particular document. Has no real bearing on the issue, because Mr. Nemirovich is the only one with firsthand knowledge of what he actually collected and what he actually produced. Petitioner represents that the Office of Special Counsel intends to produce a policy, open records policy. Again, that was in the interest of completeness. It was responsive to their most recent discovery request for production of documents, and we would introduce it, if at all, in simply an effort to show good faith and compliance with their request. Page 10 of their argument says that Mr. Nemirovich took direction from Justice Gableman. Again, there's no testimony at all that Justice Gableman. There's nothing in Mr. Nemirovich's testimony that he did anything other than hear from Justice Gableman the direction to compile and maintain and produce all responsive records, and that he did so. There's an effort to say that somehow Justice Gableman on page 10 is responsible for setting up processes and allowing them to remain in place that allowed for an oversight. There's no process in the world that can prevent oversight of clerical error, which is, again, what we've conceded, that Mr. Nemirovich, as to that those Exhibit A documents, made a clerical error that has since been rebutted or corrected. All those documents have been produced. There was nothing systematic in an effort to, and again, there's a single instance of an oversight is not a systematic effort. There is only one. So for all those reasons, again, we think that there's nothing here. The scheduling order requires petitioner to produce a witness list, including identifying any witnesses that they believe have that's a logical question for any scheduling order. And I would suggest that if in fact the court at this late date allows petitioner at this late date to subpoena rebuttal witnesses, the same leeway has to be given to us. Perhaps between now and then we decide that we're going to subpoena rebuttal witnesses. And last, I would suggest there is prejudice here because I'm advised by my client, Justice Gableman, that prior to receiving the subpoena, he was requested and has committed to appearing at a conference out of state on June 10th, this Friday, and so had not even intended to be at the hearing. And if that's the case, then I will let him make the request personally to the court to provide some other kind of arrangements to comply with the subpoena or adjourn or whatever may be necessary. So thank you. That's all I have.
Thank you, Mr. Dean. The problem with that last comment is there's no factual basis for quashing the subpoena based on inconvenience to Mr. Gableman. If that could be a reason to quash a subpoena, but I would need a factual basis, and more than just out of due respect, Mr. Dean, other than you just tell me he's out of state at a conference, I would need some very specific details. What conference? Where is it? When did he agree to attend it? What's the purpose of it? And the like. So it's not presently before me any grounds to quash the subpoena based on inconvenience to Mr. Gableman. Yes,
I understand. That's why I made the comment. I think he will have to supply that himself if he seeks to.
We're out of time, Mr. Dean. I beg the lawyer's indulgences, and I know that the two of you worked extremely hard yesterday to accommodate a less than 24-hour return on the things I asked you both to do, and I much appreciate it. But I have no time. We're on the court's calendar for Friday at 1:30, and there would be no time for me to schedule another hearing to entertain another request from Mr. Gableman for additional grounds to quash the subpoena. Ms. Westerberg, before you get going, I think rather than allow you to argue the point about a correct interpretation of the court order, I'm prepared to tell you what I think. And I'm prepared to tell you what I think because this issue comes from something that was done by the court. I actually happen to agree with Ms. Westerberg. The context of the order for disclosure of witnesses was my intent to apply to the Office of Special Counsel. At the time I had the discussion about the shifting burdens of proof, because I believed that there would be no dispute or that it was not contested that the Office of Special Counsel failed to comply with the court order, I didn't believe that the American Oversight had the responsibility or burden of proof to prove anything, but that the shifting burden would fall now on the Office of Special Counsel to present evidence from which I would find that the failure to produce the documents as ordered by the court was not intentional. And it would be, I think, the fundamental tenet of procedural due process to allow the plaintiff to know who that witness or witnesses would be that the Office of Special Counsel intended to call to lay a factual basis for its position that any violation of the court order was not intentional. The court's calendar didn't allow for a standard disclosure of witnesses. Otherwise, I would have given Ms. Westerberg the opportunity for a rebuttal witness. She did. So what happened, and you interpret, Mr. Dean, the court's form order correctly. That's the same form order I use in my standard scheduling conferences where there is a reciprocal disclosure of witnesses done in the plural. Now, what does this all mean? Well, it means something that I would be hesitant to bind American Oversight for the inartful language of the court in drafting the order, which I believe was inconsistent with the statements I made orally from the bench. So in a sense, Mr. Dean, you're both right. I think you accurately make an argument based on the language in the court order. And Ms. Westerberg, I believe you are right. You accurately resuscitate court's language made at the time it scheduled this matter. Because the fault really lays in the court for not drafting an order entirely consistent with how I articulated from the bench, I would be very hesitant to preclude American Oversight from presenting witnesses. With that explanation, Ms. Westerberg, and the reason why I don't believe that's a significant factor in my decision to grant the motion to quash or deny your motion for leave showing good cause to name witnesses, what else would you like to tell me in reply that's not redundant or repetitive to what you wrote?
Thank you, Your Honor. With that, I'll dispense with the procedural arguments based on the order and get to the extent we would still need to show good cause to amend the scheduling order. I can address some of the things that Attorney Dean mentioned in his comments. Taking the last one first, I don't know how we can get to the intent of the office without having Mr. Gableman testify for a variety of reasons. Mr. Nemerovich's deposition confirmed for us that while he might have responsibility for compiling and submitting documents in response to open records requests, he was not the ultimate decision maker of that. And I think it was conceded in Mr. Dean's comments inadvertently, maybe, when he said several times that all of this was occurring at the direction of Mr. Gableman, and not just in compiling documents, but in overall responding to open records requests. And that's part of the I think that's partly due to the process that we pointed out in our brief that's been created in the office and that was created by Mr. Gableman. Mr. Dean said that there's no process in the world that's going to avoid mistakes. But this process was uniquely, as we've been learning, set up to create problems and to be unduly complicated and yet underly responsive. And I think that they admit that in we could go into detail, but they admit that in their brief, at document 225, page 17, they said the OSC's conduct constitutes nothing more than the ordinary course of complying with an order to produce documents in which an organization with very limited resources may often intentionally omit documents. So I think they've conceded that their process is not designed to consistently produce documents as required. And that certainly came through to us. And I think we need to hear more from Mr. Gableman about that, because I think it led to many of the problems in responding to American Oversight's requests that are the subject of this litigation, as well as the court's order. There were a number of inconsistencies in Mr. Nemerovich's testimony, which we mentioned in our brief. There were a number of gaps in his knowledge, some of which we mentioned in our brief, but there was gaps and inconsistencies of who really compiled all of those documents for the January production. Mr. Dean makes the point that there's really nothing at issue at this point, because they produced the documents that were inadvertently withheld, and then they've retrieved all of these email attachments that had been deleted. We don't agree with that, and that everything is, all of the issues are resolved or all the records have necessarily been produced. I would point out that the Office of Special Counsel knew actually in January 31st, before that date, that these attachments had been deleted. And they still didn't produce them.
Ms. Westberg, can I interrupt just because you make a mention of the January court order requiring the Office of Special Counsel to produce a response to American Oversight's request. I've reviewed the language in the order. I don't believe that at that time anybody knew that the Office of Special Counsel had printed the electronic documents and deleted the electronic file. Is my recollection correct?
That's certainly true on as far as American Oversight goes. We didn't know that. We did learn it later on. the Office of Special Counsel mentioned that in one of their letters or court filings. You see that at document 200 at 2, footnote 2. They say the OSC did not discover that such hard copies failed to include certain attachments until counsel reviewed the documents prior to its January 31, 2022 production. However, the identical digital copies had already been deleted.
Ms. Westerberg, American Oversight had asked in its public records request that the documents be produced in their original digital format, correct?
I don't remember exactly the language that we had on that. I think the language might have been produce it in electronic if available or something to that extent. I don't have that on the tip of my fingers. But I will say that.
But if that's true, which I believe it is, does American Oversight still desire to receive electronic or digital responses to its original public records request?
Yeah, I think that would be the most convenient.
And that has not been done to date.
What we've received mostly, I think, is scanned copies of documents. As for these attachments, we've gotten them electronically. I think they were sent by file sharing site in May, but I think the overall issue is that the Office of Special Counsel has a process and practice of not only deleting electronic copies of or electronic copies of documents it's printed, which obviously can lead to a lot of problems, but it also has a regular practice of deleting all electronic or most electronic records. And we learned that from Mr. Nemirowitz too.
And assuming the court's order did not address the format in which the response, but contained language requiring the Office of Special Counsel to respond to the request as it was made, does American Oversight intend to make an argument on Friday that the Office of Special Counsel intentionally destroyed the document in its digital format, notwithstanding having been previously asked for it to be produced in that format?
Yes, I think we intend to argue that the overall process has led to the deletion of documents that American Oversight has requested. And to the extent that the Office of Special Counsel is belatedly trying to produce some of them now, that has led to a delay, which of course is actionable under the Open Records Law as well, that they've unduly delayed release of these records, some of which still seem to be trickling in.
And do you know who made the decision to destroy the digital copy of the responsive records?
I think that was a policy that came from Mr. Gableman, but we would like to question him on that point.
All right. Okay, I'm sorry to have you interrupt your train of thought. Please continue, Ms. Westerberg.
I don't think I have too much to add beyond what was in our brief. I think Mr. Dean referred to at some point Mr. Nemirowitz as the chief of staff. I think that's true for the current period. It was not true at the time that the Office of Special Counsel was responding to any of our requests or the court's order, or even maybe as late as this spring. Again, that's another thing that we need to discuss with Mr. Gableman on Friday. And Mr. Dean said that they do not concede that the violations of the court's order that it has committed were intentional. Again, we do intend to argue that it was, and we'd like to have the evidence that we need to do that. We did want to give the Office of Special Counsel the benefit of hearing from their witness that they had designated on this, but it's become clear to us, particularly after taking that deposition, that we'll need something more.
Westerberg. Mr. Dean, it's your motion, so you get the final word.
Thank you, Your Honor. I had to take it off mute. I was trying to avoid your hearing my what the question you raised with Attorney Westerberg. I did go back and look at the court's January 25 order, and the order was specifically that on or before Monday, January 31, 2022, the Office of Special Counsel shall file all records, documents, and things responsive to the petitioner's request under the Open Records Law. And then it went on to talk about filing under seal. So at that point in time, again, as Ms. Westerberg points out, other than that small group of contracts, calendars, and a couple other things that were produced as Exhibit A, at that point in time, the Office of Special Counsel produced to their counsel, to me and Attorney Bob's firm, all of the documents they had that were responsive. It was at that point in time we realized that those deleted attachments did not exist. We realized later that this Exhibit A, the contracts and so on, did exist, but were inadvertently omitted. And as soon as we became aware of both of those, we began taking efforts, and then Attorney Westerberg calls it trickling in. No, they're not trickling in. There were two and only two productions. One was to produce Exhibit A on April 8th. Those were all documents, responsive documents that the Office of Special Counsel had on January 25th that were inadvertently admitted. The others produced on May 13th, I believe, under cover letter was Exhibit B, and again, that was the result of a truly Herculean effort by Mr. Nemirovich to contact every last person on every last email and to recover electronic copies of all of those records. So this idea that somehow we're trickling in, or somehow there's more, there have been two and only two productions, period. And again, I'll make the distinction and stand on that distinction to the extent that a violation of the Open Records Law occurred pre-litigation and pre-January 25th by deletion of electronic records after printing off hard copies. That's not what is at issue before the court. The only thing at issue on Friday is whether as of January 25th, there was an intentional violation not to produce those records that it had. And I would also suggest that.
But let me disabuse you of that, so you can prepare appropriately, Mr. Dean. Here's what I would like to hear from the Office of Special Counsel. An explanation of the following. The American Oversight made its public records request on October 26th. One of the issues, I think, has been debated. It needs to be decided. The public records law does preclude a custodian from deleting or destroying records after receipt of a request. Assuming the request asked for the records in the native format, a digital or electronic format, which I believe it did. There are cases that say that a public requester has the right to request documents in that format. I understand the Office of Special Counsel believes that it is not subject to the Document Retention Act that applies to the legislature and others. But I would like to know, so we worked through the fall up until the date of January. I don't believe anybody was aware that the Office of Special Counsel had taken the position that the Document Retention Act didn't apply to it and was apparently routinely deleting electronic documents, believing that simply printing them off was an acceptable substitute. So I'm not sure I read the question define the issue so narrowly, Mr. Dean. The question is what did the Office of Special Counsel do after it received American Oversight's request? When did it do it? And did anybody know when I ordered OSC to produce the documents pursuant to the request that OSC had, after the request being made, but before the court order, destroyed a document in the format in which it was requested, thereby subsequently saying, well, we deleted the electronic, so we can't produce it now anyway. I think I don't know the end of the story. That's why I think I'd like to hear it from one witness or another. And Ms. Westerberg is saying that that's not really Mr. Nemerakovich's story to tell. It's Mike Gableman's. You disagree?
I disagree. The fact, the only thing that matters is the facts. The questions you ask, which of course are the appropriate legal questions, are not going to be answered by Justice Gableman or Mr. Nemirovich. They're going to be answered by the court on appeal. What matters is the factual evidence. What was deleted? An electronic email, for example, was deleted, but only after. And again, they will testify. And I know this is repetitive. But they will testify they printed hard copies of all emails. When we realized after January 25 that attachments had been deleted, we've gone through the Herculean effort of recovering and have produced now and filed literally all of those deleted attachments. And the question is, and again, this is why I started the way I did, the question is not whether there was a violation of the open records law pre-litigation and the courts and pre-January 25 order from this court. The question is, post-January 25, did the court or did the Office of Special Counsel deliberately and intentionally violate the January 25th order? And the answer is no. They could not possibly have violated a January 25th order based on conduct that occurred before it.
Why didn't the Office of Special Counsel tell me before the January 25th order that it had destroyed the electronic copies?
Before the January 25th order?
Right.
That was I don't know that we had a duty to. The question then was...
The reason I asked you the question, Mr. Dean, and I'm not making a decision today, but I wanted you to be prepared because Friday I am going to make a decision.
Certainly.
Had the Office of Special Counsel said in early 2022, before I entered the order, that I just want to let you know that although American Oversight asked for the electronic copies pursuant to our policies and procedures, we don't have those. We do have paper copies, and we will produce those in compliance with the court order. I would agree, had that been told to the court, that the issue would be so narrow as you describe it. That the only question is did OSC do what I ordered it to do? But I believe the order that I issued did not differentiate between the producing the paper copies as opposed to the records in the format in which they were requested, because the Office of Special Counsel had not informed the court that it had taken that action. And my point is, you can violate a court order if the court orders you to do something, even if you can't do it because prior to the court order you ignored the Document Retention Act and destroyed the electronic copies.
Well, Judge, I would argue that that is not the way, certainly not the way I understood the court's January 25th order, and I would respectfully submit that that's not the way the court understood it either. because on January 31st, and again, we had that long exchange, and I actually wrote a subsequent letter, because of and truly after my experience last night and early this morning, dealing with the limitations, shall we say, the size limitations of electronic filing, I did call the court's clerk. I physically drove over the entire hard file of physical copies of all of those documents. That's what I gave to the court. I truly believe that was in compliance with the court's order. If the court was expecting to receive electronic copies at that time, the court logically would have asked me, well, where are the electronic copies? Why is there not a jump drive or something with those electronic copies on? This is, I do understand your distinction now, but in all sincerity, Judge, this is the first time I've realized that in your opinion that distinction was significant. There are any number of, everything that we've produced has been actually in electronic form to counsel. Ultimately, even yesterday, all of those are scanned images. I will actually go to work, and I truly appreciate the court's indication of this issue. For example, one of the first things I have to begin working on in the next 48 hours is, what does that actually mean? If in fact, I will go back and read the open records request. If in fact they're asking for emails, that opens up a whole universe of issues about data security, metadata.
Okay, so there are, Mr. Dean, there are cases on point. This issue has been litigated, and there are appellate decisions on whether a custodian has to produce a public record in the format in which it's requested. All right, Mr. Dean, I interrupted you. Is there anything else you'd like to say?
Oh, only one thing. And the court mentioned that the hearing was 1:30 Friday. I checked. I believe it's at 9:30. That's what I have on my calendar. So I just want to make dead sure.
I did misspeak. I apologize. It is 9:30.
Okay.
I was looking at the calendar and it said 1:30, but that's today. Thank you very much, Mr. Dean.
All right. Thank you.
All right. Again, I appreciate your hard work, both you, Ms. Westerberg, and you, Mr. Dean. Not to ignore you, Ms. Sloan, or Ms. Colombo, or Mr. Stadler, but there's been a lot of work done in the last 24 hours to get me to a position in which I feel comfortable ruling on the pending motion. I'm going to deny the motion to quash for the following reasons. First, I previously indicated to you that the disclosure of witnesses was intended by the court to apply to the defendants. The order, the form order that I used for my standard scheduling order did not correctly correspond to the instructions that I gave on the record at the time I required the OSC to disclose its witnesses to testify on the question of whether its actions were intentional or not. I do believe, as argued by Ms. Westerberg, having re-reviewed the transcript, that it would clear that I only required the OSC to disclose the witness because of the press at time. There was no schedule discussion about rebuttal witnesses. I do note that there can be rebuttal witnesses designated at a late date if the need requires after a party takes a deposition. I'm going to deny the motion to quash secondarily because I do not believe the subpoena to Mr. Gableman should come as a surprise to the Office of Special Counsel or to Mr. Gableman. Indeed, Ms. Westerberg had indicated early on that she was taking the deposition of, I always say Numerowitz, but that's not the right pronunciation.
Mr. Nemirovich is here. It is Nemirovich, correct?
Correct, it is Nemirovich.
Mr. Nemirovich. The record will reflect that Mr. Nemirovich appears alongside Attorney Mike Dean. The American Oversight, Ms. Westerberg had indicated, I think it was in a footnote in one of the briefs, that she was taking the deposition of Mr. Nemirovich, and depending upon what he would say, they very well may need Mr. Gableman's testimony. The explanation for the timing of the subpoena on Mr. Gableman is explained in part because of, understandably, Mr. Dean, your health and the delay. Suffice to say, it's Ms. Westerberg's representation to me that what she foreshadowed in her brief about the questions that she now has after taking Mr. Nemirovich's deposition thereby necessitate the testimony of Mike Gableman. I'm going to deny the motion to quash third because I do not find that Mr. Gableman or the Office of Special Counsel has satisfied me that subpoena to Mike Gableman is prejudicial or causes any harm. The request for Mr. Gableman to testify is not like adding a surprise witness, a third party that no one has ever heard of. Indeed, Mr. Gableman is a party to this action. He has participated in this action. Apparently, he participated in Mr. Nemirovich's testimony. To the extent that the subpoena comes at a late date, Mr. Gableman may already have be prepared to be questioned on the witness stand, and there is plenty of time between the service of the subpoena and Friday's hearing to prepare Mr. Gableman for his testimony. Therefore, I do not believe that it was unfairly surprising to him that he would be needed at the hearing on Friday. I'm going to deny the motion to quash fourth because it is undisputed that Mr. Gableman is the custodian of the Office of Special Counsel records. He was the custodian at the time the request was made. He was the custodian of record at the time the answers were provided. And indeed, after reviewing the two versions of the open records policy found in documents 146, scanned in on January 31st, is substantially similar to the new open records policy, document 298, scanned in on June 8th. The last sentence upon being that upon transmission, that is transmission after his final report, the special counsel, which is Mike Gableman, will cease only at that time to be designated custodian of records under Wisconsin state law pursuant to section 19.33. It is entirely appropriate. Indeed, I would have been puzzled had not the custodian of the records appear in court when it is leveled the accusation of an intentional disobedience or violation of a court order. And finally, I'm going to deny the motion to quash upon the representation, I think, of Ms. Westerberg, that either Mr. Nemirovich implicates Mr. Gableman or has imperfect understanding of the facts necessitating Mr. Gableman derived from the question and answers during his deposition. I do not have a copy of the transcript, probably understandably because the court reporter hasn't prepared it, and I'm relying on counsel as officers of the court to accurately recite it to me. But suffice to say that it appears Ms. Westerberg, having predicted that she may need Mr. Gableman at the Friday hearing, characterizes the answers given by Mr. Nemirovich in his deposition as to now requiring Mike Gableman to testify. Even if I accepted the argument that the order required the American Oversight to designate witnesses, which it did not, I would grant the plaintiff's motion to allow it all name Mike Gableman as a witness for the same reasons that I would deny the defendant's motion quash. I believe that case of this litigation, embodied in the language of the public records law, that suggests, if not requires, the court to expedite litigation and give precedence to public records disputes, has been such that there has not been a lot of time to do a standard scheduling order that would have pushed this case out into the latter part of 2022 or 2023. Now, Mr. Dean, if you believe that the Office of Special Counsel needs a rebuttal witness in addition to Mr. Nemirovich and in addition to Mr. Gableman, certainly I would entertain that request, and I would endeavor to apply the same standards that I have endeavored to do for the request by American Oversight that it be allowed to question Mike Gableman on Friday. No request has been made to the court at this time. So for those reasons, I'm denying the motion to quash, and alternatively, even if there wasn't a motion to quash, I would grant the plaintiff's motion for leave to name, call, and question Mike Gableman at the hearing on Friday, on June 10th. All right, there is another matter that I want to bring up, and I'm glad Mr. Nemirovich is appearing here. It seems to me, Mr. D, that in arguing that Mr. Gableman is not necessary, that Mr. Nemirovich was tasked by the office and given the responsibility by Mr. Gableman to do what needed to be done in response to the public records request and in response to the court's order. It seems to me that the Office of Special Counsel is putting the responsibility for the question now before the court directly on Mr. Nemirovich's shoulders. Am I correct?
As to the physical execution of the search, yes. In
that respect, a standard, I think, requirement of substantive, if not procedural due process is when the court entertains a motion for contempt, understanding that one remedial sanction can be incarceration. I wonder whether Mr. Nemirovich has been apprised of the possibility that he may need to seek independent legal counsel if, in fact, the strategy of the Office of Special Counsel is to place the failure to comply with the court's order squarely upon his shoulders. Because I'm not sure Mr. Nemirovich's interests now have not diverged from the interests of Mike Gableman or the Office of Special Counsel itself. I'm not suggesting there's a conflict of interest. I am saying that I always proceed very carefully and extremely cautiously when the question before the court is contempt, and where one of the sanctions that could be imposed is confinement in the Dane County Jail. I just raised the issue because I don't believe anyone is served, certainly not Mr. Nemirovich's interest, by having this occur to him spontaneously on Friday's hearing. I don't know that it's been discussed. It might not have occurred, but I do think a discussion may be warranted because Mr. Nemirovich's personal interest might be to escape the scrutiny of the court for the deficiencies that appear now to be undisputed, that he was acting at the direction of Mike Gableman, and Mike Gableman told him what to do, how to do it, when to do it. That very well may be grounds for the court to find that the individual who is responsible for following the court's order should be relieved of his failure. I don't know. But in reviewing the documents and understanding the arguments and in consideration of why the Office of Special Counsel does not believe Mike Gableman should be there, knowing that Mike Gableman is going to be there and also Mr. Nemirovich's, I just think it would be appropriate to have a discussion over whether a potential conflict exists. If so, whether there's a knowing and written waiver or other discussion. I am not suggesting that anyone has done anything wrong or that anyone has failed to do anything. It just appears to me at this juncture of the litigation, the interests may be diverging, which would cause this individual to look perhaps possibly to his own personal interest, or at least have a discussion with an attorney either provided to him by the office, by you, Mr. Dean, or by his own choosing.
Well, thank you, Judge. I would just submit that the incarceration for contempt based on the record before the court that it might even conceivably be represented would be incomprehensibly disproportionate. That's how it strikes me.
Well, you may entirely be correct, but my experience, Mr. Dean, in this serious matter is to afford all the individuals who play a role in a disobedience of the court advance notice of the possibilities that could occur so they can prepare accordingly. This just occurred to me for the first time, having read Ms. Westerberg's response brief and truly understanding possibly the strategy of Mike Gableman in the Office of Special Counsel to put the sole responsibility of the deficiency on Mr. Nemirovich's shoulders. Now, like I said, I'm not accusing anyone of anything wrong. I do believe it's a discussion that should be had so we don't have a problem on Friday if it were to come at that late date. Ms. Westerberg, is there any other I do know. There is one more matter before the court. I do want to schedule a hearing on a loose end, the plaintiff's request for fees and costs. It's now fully briefed. I haven't heard back from the Office of Special Counsel whether it accepts your agreement to allocate the apportionment of fees and costs appropriately and thereby moot the joint and several argument issue that was raised. And if that's an agreement of the parties, then I need only examine a finite number of particular bills to make a ruling on those. To your understanding, Ms. Westerberg, do the parties have an agreement that the issue of what I call joint and several responsibility or lack of apportionment, is that resolved?
We've not had any further discussions about that, Your Honor, since the briefing, and it seems like we're generally in agreement with Mr. Voss and the Wisconsin Assembly on that, in particular with Mr. Stadler's clients. Mr. Dean's clients, I don't know.
Well, I would like the lawyers to talk about that. And I'd like them to talk about that at some point over the next 2 weeks. And I don't know, Mr. Stadler, maybe this is an issue that you are most appropriate to take a lead on, given that you represent Representative Voss and the Assembly.
I can do that, Your Honor. It was our suggestion to split it that way. I will check with the Office of Special Counsel, and if we have an agreement on that, we'll advise Ms. Westerberg and the court of that.
Right. Because if I understand the procedural posture, Mr. Stadler, Ms. Westerberg essentially accepted your proposal. And by accepting the proposal, am I correct that then there no longer exists an issue that I need to decide?
As to the splitting of those fees, I think there were some objections as to some of the particular entries within those, but we did agree that for those that you couldn't delineate between the two parties, to split them evenly.
All right. Okay. So then I'm going to, right now with your calendars open, I'm going to ask my clerk schedule a hearing to finish up on the fee request. I find it most efficient then to go over on the record with the opportunity to be heard the questions of the individual entries that the defendants have objected to. But then I would rule on those entries, whether they're appropriate and should be included in the fees taxed or inappropriate and deducted. And that can be done most efficiently orally through a exchange of information between and by counsel. Because I have you here, let's get a date on the calendar for ruling on American Oversight's request and correct computation of its fees. Oh, Pam, I see you're there. Pam, let me look in the calendar here. How about July 13th by Zoom?
This would be on the fee issue itself, Your Honor?
Just the fee issue. It's going to be fair. If it's just the dozen or so specific objections that were made to particular entries, it should be very quick. If it, assuming the apportionment issue has been resolved, but it's only related, and to finish up American Oversight's, what I would say preliminary fee request, understanding that it continues to incur fees and costs through the continued litigation of this case.
I'm available on that day, Your Honor, and would say that I'd be willing to come in person as well. Zoom hearings are okay.
Yeah, I think I would do this one only by Zoom because there does seem to be some interest in members of the public, and because I can facilitate live streaming, I can do that easily by Zoom. Also, it affords the opportunity for counsel for American Oversight not local to view and participate. Ms. Westerberg, is that time? Is that, I think, either morning or afternoon?
Thank you, Judge, and thanks for accommodating counsel who's out of town. The 13th is good for us in the morning.
Okay, 8:30. Mr. Dean, I don't know if Office of Special Counsel follows behind the Assembly and Mr. Voss, or whether you, but does that date work for you?
It works for me, but I'm not lead counsel and would not be handling that hearing. So if you set it, go ahead and set it. Attorney Bob or Attorney Milburn, I'm sure will then move to amend and consult. They just are not, because of other litigation commitments, they're not able to participate today.
Okay, one more reason to make it by Zoom to accommodate our colleagues from Indiana. We'll send out a notice for 8:30 on July 13th, and that will be to finish up on the American Oversight's motion for fees and costs having prevailed on the underlying case, and to rule on the individual objections made. All right, anything else, Ms. Westerberg?
Not from us, Your Honor.
Mr. Dean, anything further?
Not at this time, thank you.
Mr. Stadler?
The only thing I would add, Judge, is I've been silent today on the issue of the motion to quash. I do intend to argue on Friday in regard to the issue of contempt, given that American Oversight is trying to impute that on my clients.
Okay. I'll wait with bated breath. Ms. Westerberg, would you please prepare an order for the court's signature memorializing the court's ruling made orally from the bench denying OSC's motion to quash and alternatively granting American Oversight's motion to amend its witness, to amend and name Mike Gableman as a witness in the hearing to be held on June 10th.
And do.
Thank you very much. We're adjourned to resume 9:30 this Friday in person in